Good evening. Today is Sunday the 9th of October 2016 and I am Karen Harding, a criminal defence lawyer from Auckland, New Zealand. I am counsel representing 30 fishermen in relation to wage claims stemming from working on vessels Oyang 77 and Oyang 70 in New Zealand waters where they were not paid the minimum wage. They worked on Korean fishing vessels owned and operated by a Korean company in conjunction and partnership with a New Zealand company, and they came here on New Zealand work permits and they were abused and exploited at sea. On the 12th of October 2016, in just 2 working days, we are going to be having an appeal at the Court of Appeal in Wellington in relation to whether they can apply for relief for forfeiture to sell what is known as a sistership, Oyang 75, which has been forfeited to the Crown for fishing crimes, to pay their unpaid wages. So this is video 4, following on from 3 videos made from yesterday. I'm just going to have a little bit of a talk about what can lay behind wages and how wages can be claimed over a vessel. So that leads us to a discussion about something called maritime liens, which is covered in section 5 of my submissions for the Court of Appeal. So a seaman can claim his wages over the vessel he worked on, even if it's wrecked, as long as a single plank remains. This applies to fishermen or people that work on ships. This is called a maritime lien. So the maritime lien attaches to the maritime property, such as the vessel, and it has the nature of a secret charge. You don't have to register it at the bank or with anyone. It just exists the moment that you have wages outstanding. A purchaser, other than in a judicial sale, which is a court sale, is bound by any pre-existing maritime liens. So even if someone bought the vessel and they didn't know that the owner of the vessel that sold it to you owed you wages, you can still claim, and the new owner would be liable for those wages. So the maritime lien's very important and powerful. In our situation, there were 3 ships working here in New Zealand. Oyang 70 sank. So unfortunately there is no planks left to claim the maritime lien over that ship. There were 2 other ships though, Oyang 77 and Oyang 75, which became forfeited to the New Zealand government on the conviction of the captains who worked for the Sajo Oyang Corporation for fishing crimes. So discussing these maritime liens, so it's against the owner or the demise or barefoot charterer. A maritime lien survives the sale of vessels or the change of ownership where the purchaser is a bona fide purchaser for value and didn't have notice of the claim about the unpaid wages. And the maritime lien doesn't require possession, so the sailors, fishermen, seamen do not have to be in possession of the ship. They don't have to be on the ship, they just have to have outstanding wages. And this claim, which is also known as a privilege, travels with the thing, i.e. it travels with the vessel into whoever's possession it may come into. So it passes to each new owner. So under English common law also, the maritime lien can be enforced against a sister ship. So if you've worked on a vessel and the company owes you money, you can enforce that over that ship you worked on and also over another ship. And we call that a sister ship. For example, if you have a brother or sister to either one of your parents or to both of your parents, that is your sister. So they have sister ships, another one owned by the same company basically. In the maritime jurisdiction, when you try to enforce your maritime lien over the sister ship, it is slightly less in rank of priority for payouts, and it's called a statutory in rem claim. And consequently, they have less priority than the people who worked on that ship. So to make a claim over the sister ship for unpaid wages, you're allowed to do, and people who worked on the ship can make a claim over their own ship that they worked on for unpaid wages. And if that ship gets arrested and the court agrees that there are outstanding wages, then the vessel will be sold to pay the wages, and the people who worked on that ship get paid out first. Then the people who worked on the other ships who are claiming wages in that sister ship, they get paid out second. And so that's sort of quite important because it's done in a sort of a priority order, and the court has to work out the priority order. The problem is that if a vessel is forfeited to the government, the Crown as we call it in New Zealand, for a fishing crime, then that extinguishes encumbrances, including the maritime liens. So the government, the Crown, when a vessel is forfeited by the court for fishing crimes as part of the statutory punishments for that fishing crime, the Crown gets it free and clear. That includes mortgages and other debts and other things over it, and these maritime liens. It just gets it free and clear. And the mortgage stays with the company, with the owner, but it stops being connected with the ship. So the Crown and the government just get the ship and all its worth and none of its debt. Accordingly, when Oyang 77 and Oyang 75 ships were forfeited, Oyang 75 was forfeited to the Crown for fishing crimes on the 29th of September 2012, and Oyang 77 was forfeited to the Crown on the 3rd of September 2014. So that means that the Crown's legally owned those ships since that time. You might think, well, that's quite a long time ago, because now we're talking about being in October 2016. But it's not really an issue, because the owner of those ships spent 2 years appealing things that happened in relation to the sentence about that, trying to get special reasons, and going through the High Court judicial reviews, the Court of Appeal, and had to go at trying to go to the Supreme Court for an appeal, and that took 2 years. So nothing's happened really with those ships, other than the Crown released those 2 ships to be able to be used by the owner of those ships, the Sajo Oyang Corporation, so they could go back out fishing. So they've been earning that company, the Sajo Oyang Corporation, money over the last up to 2 year period, including now. And they have apparently the Ministry of Primary Industries, who's really the Crown agency involved in this saga, has apparently got a bond over them, and can bring those vessels back should they be required. So that is okay, because it stops port charges, because if those vessels were going to stay in port for 2 years or 3 years, however long this case is going to take, because it took 2 years to get to the point of making the first application for relief for forfeiture on the 16th of April was the first hearing, and then it has been sort of another 18 months since then to get up towards the Court of Appeal hearing. So you're already going up towards 4 years in relation to Oyang 75 anyway, so it's not really an issue. But the Crown doesn't have to pay the wages, they can just keep the ship. So if we want to get these crew members paid who have wages outstanding from December 2007 through to October 2011 in relation to the 30 that I'm representing, and there's 26 the subject of this appeal, because it relates to hearings that took place on the 16th of April 2015, and a decision also delivered in July 2015 that has gone off to appeal. And at that point, when those hearings were going on, there was 26 fishermen who'd applied for relief for forfeiture on the 16th of April 2015, and a 27th one had applied on the 7th of July 2015, which did coincide with the next hearing, but that was via a telephone conference. So he's just basically sort of an applicant in waiting. And the additional numbers that take us up to 30, they're also sort of applicants in waiting, and I'm going to file applications for them. But we haven't been able to get a court date at the Christchurch District Court, which is the Forfeiture Court, dealing with these relief for forfeiture applications because of all these appeals going on, because there's been appeals also through at the High Court at Christchurch concerning decisions that were made in the District Court at Christchurch, which is the Forfeiture Court. So Section 256 of the New Zealand Fisheries Act provides a provision and a process to determine the value of any quotation mark interest in the vessel and unpaid wages, and it provides a process through an 11 subsection section 2561 all the way to 11 to determine if relief should be granted and whether that would relieve a manifest injustice. and we say that there are outstanding wages, the process under section 256 is able to determine that, and it will be a manifest unjust justice cause if they're not given relief from forfeiture. But for the forfeiture of the sistership Oyang 75 and Oyang 77, the crew members from Oyang 70 could assert their right to be paid wages out of Oyang 75 by arresting Oyang 75, which they could have done if it was still in New Zealand, but at the point that it gets forfeited, it's not, able to fish here anymore, and the government's crossed with them to fisheries offences, so their time was up. So if that ship hadn't been forfeited, the crew from Oyang 70, which is the vessel that sank, could have asserted that they should have been paid their wages over the ships owed by the Sajo Oyang Corporation. And this would have been by way of something called the Statutory lien, which is provided for under section 5 round brackets 2 round brackets little b round brackets 2 little i's of the Admiralty Act 1973 in New Zealand. And so the crew under Oyang 70 and Oyang 77 can also, in our common English law, claim a maritime lien over the sister ship for their unpaid wages. And so that leads us up to why we've made the claim under section 256 round brackets 1 round brackets little c of the Fisheries Act 1996, seeking relief from forfeiture from other forfeit property. So we assert that under section 256 round brackets 1 round brackets b, that my clients, being the fishermen, have an interest in unpaid wages from working on vessels that were owned by the Sajo Oyang Corporation that were involved, who were fishing in New Zealand and they weren't paid. And we make the claim under subsection C over something called other forfeit property. We're saying it's other forfeit property because it was a vessel that was forfeited, and a vessel is property. It's other because it was a ship they didn't work on, so it was other to them. It wasn't their ship, it was the other ship. And we say they should be able to make a claim, and that we should have relief from forfeiture, but because the vessel was forfeited, the government's interfered with our ability to arrest that ship and to bring an in rem claim. And what's happened is the Sajo Oyang Corporation, through their lawyer Bruce Squire QC, and the Crown, represented by the Ministry of Primary Industries prosecutor from the Crown Sisters Office in Christchurch, is saying to us, if you want to get relief from forfeiture on Oyang 75, you should have made an in rem claim over Oyang 75 before it was forfeited and gone off to the Admiralty Court first and had your wages determined in the Admiralty Court, and then come to us at the Forfeiture Court to ask for relief. But for my fishermen, that was impossible. Although they had got off the vessel in my case before it sank on Oyang 70, and off Oyang 77 at the latest in 2011, they didn't get lawyers until January 2015, that lawyer being me. No one would help them. They'd gone back to Indonesia, they're impoverished, they don't know their rights, they knew things had happened to them that were wrong. They had contracts that specified they would be paid US $200 a month. Some had $220 a month, up to $290 a month for a couple of them. So that does not in any way, shape or form coincide with the New Zealand Minimum Wages Act. Under the Fisheries Act 1996 and Section 103, the fishermen are actually guaranteed the right to be paid the minimum New Zealand wage for every hour that they work. So what was the New Zealand minimum wage? Well, at the period my crew were working on Oyang 70, between the 1st of April 2008 up to the 1st of April 2009 for an adult, the minimum wage was $12 an hour. There then was a pay increase on the 1st of April 2009 to the 1st of April 2010 for an adult, up to $12.50 per hour. Then they got another 50 cents pay rise on the 1st of April 2010 to the 1st of April 2011 to $13 an hour, and another 50 cent pay rise from the 1st of April 2011 to the 1st of April 2012 up to $13.50 per hour. In addition, there's a code of practice for foreign fishing crew that was in force since 2006 that said foreign fishing crew would be paid an extra hourly rate. We call it the extra top-up hourly rate, which from the 1st of January 2007 to the 31st of December 2009 was an extra $1.25 per hour on top of the minimum wage. Then that had a little pay rise from the 1st of January 2008 to the 31st of December 2009 to an extra $1.75. Then they got an extra 25 cents the following year when it went up to $2 an hour. We also say they should be paid holiday pay, because every other worker in New Zealand who's here on a work permit is required to be paid holiday pay, and we say that should apply to them, so they didn't get that as well. So what's at issue here, which ends up being millions of dollars outstanding, is that you've got crew working 686 days each, and you're 30 people. You add up every hour they did, and they didn't just have a 9 to 5 kind of job. They worked on average 18 to 20 hours per day, and they didn't have regular shifts, so they were always on. When they went to bed, they'd get woken up in their sleep to come back. So actually they were on call 24 hours a day, 7 days a week for the duration of each contract. The contract's for up to 2 years. So for a 2-year period, working 7 days a week, working those hours and on call with no personal time, deprived sleep, they need to be paid on a sort of a 24-hour basis, because they're on call 24 hours a day and they can't get off the ship, and they have to work all the time on demand. So when you add that up for the minimum wage and the top-up rate, plus what the holiday would pay be, it's quite substantial. And this is because you deduct from that what they got paid in their Indonesian salary, but their salary was really nothing. So some of them only got $3,000 to $4,000 for working up to 2 years on the vessel. And for those that got sent home early when things untoward happened to them, they got financially punished with assets taken off them, and the airfares and things taken out of those pittance of wages, and other financial costs put on them. So they basically ended up with almost nothing for working for a long period on these ships. You work for over a year and ended up with basically almost nothing. And on top of that, they worked in abject conditions. So they worked in very cramped, dirty conditions. So there was vermin there, cockroach infested, their bodies were being bitten by cockroaches, their beds were wet, they had old bedding, old mattresses, so that when they came on the ship they had to use mattresses and blankets already used by someone else. And you think, oh well, maybe that's not a big deal. It was, because they had no access to fresh water for bathing in or for washing their clothes, and if they tried to use the washing machine, it was broken, so they couldn't use it, and if you tried to sneak off and use the Korean officer's one, you got punished. So that's really unhygienic, and so they're trying to wash their clothes by putting them in the net sort of thing and dragging them behind the ship. So everything's like dirty and stinky. The bathroom facilities were really terrible, so that they were having to bathe together in like one big bathtub, because the Koreans don't sort of like to provide showers, so they just have one gigantic bathtub. That's the bathtub there, that one, and that was the toilet next to it, that toilet, and the picture above it with the sink with a bit of orange around it, that's the kitchen, and then that is the bedroom. So they're working in conditions that are really appalling. The food was horrible. It had fleas, bugs and insects in it. It was of low nutritious value. They worked exhausted. They had lack of equipment. They tried to make their own gloves out of things they brought from home to try to protect their hands. There were injuries on board. One of my clients' career as a fisherman is completely ruined from losing his finger in an accident where he tried to save the Korean officer's life, and in turn he had to have his finger amputated because it was half cut off. And on top of that, they were abused. There was racial and physical abuse, bullying, and assaultative behaviours. The affidavits that I've taken from each of the fishermen collectively make a very serious indictment of what's happened on that ship. There were fishermen that were dragged across the decks by senior officers, put in a room and hit with ropes. Sexual assaults occurred on a daily basis. That was really traumatic. The insults and watching people being abused was just really quite traumatic, and they worked in fear. And on top of this sort of wages situation, you think, well, why didn't they just get off the ship, run away? Well, they can't, because the agents for the Sajo Oyang Corporation had them put up security, and the security was their parents' house or paddy field. So if they left the ship or absconded when it came into port to unload the ship, then the agents would seize their parents' property and the whole family would become homeless. And obviously the paddy field's really important because these people live on or above, or basically on or under the poverty line, and they're trying to work in New Zealand on fishing boats to get just above this poverty line to feed the families. And to take the paddy field is just the cruelest thing, is you just can't go home like that. For those that didn't have assets, whose parents didn't have any property, they had to put up vehicles, and it's really hard for this lot to get a vehicle. They come from a place of poverty. One of my clients didn't have a vehicle. He put up his neighbour's vehicle, so that was in a rural area, and that vehicle meant everything to the next door neighbour's family, and his family didn't even have one. Another one of the clients put up his mosque leader's house certificates. So if he'd have come home, the leader and his whole community would have lost everything. And there were people who had nothing and didn't know anyone with anything, and they had to put up their graduation certificates from primary school to get the job, because most of these clients also hadn't finished primary school. And to finish primary school in Indonesia is quite a big thing. So it's really sad what happened. They worked really, really hard. They were abused. They were economically exploited. In my view, it meets the criteria for human trafficking or forced labour, because they worked under this definition of the financial penalty. So where the security was the threat, it kept them there. So they wanted to work. They wanted their $200 a month. They're entitled to so much more under the New Zealand Minimum Wage Act, and that threat that they weren't going to be paid was always over them. And how it was set up is that the Sajo Oyang Corporation also withheld wages under that contract. So even the $200 a month they were supposed to get was withheld for the first 3 months, or sometimes up to the first 5 months, which meant that the families at home got no money. And that's the reason why they're working, to support wife and children. So most of those people were married people. And they're professional fishermen. And what happened on Oyang 77 was just really awful. There was just so much abuse on that ship, and the conditions were really awful. They sort of describe it as a floating rust bucket. And many of the people that worked on that ship were seasoned professionals, and some had been working for the Sajo Oyang Corporation for a decade, and that was the last straw. And several of those people will never ever go back to sea again. They've had their careers ruined by injuries, and their health deteriorated from the enormous stress on their hearts, for example, for working all those hours with such bad food and such poor conditions. And they also talk about the mental health side effects of that. It's like hugely depressing. They speak about it, I think, feeling broken-hearted, which is their root for feeling really severely depressed. They're trapped in a situation, they have to earn money. If they go home, it causes great shame to go home and give up on a job, because no one really fully appreciate how horrible this was. But to go home would be worse if it was going to lose houses and paddy fields. So they're really in a bind, and they really need their wages. And why New Zealand needs to care is because this happened in New Zealand on a work permit. And it happened at sea, but that's no different from it happening at your place of work, or picking strawberries, or in a factory. If it's in New Zealand, it's in New Zealand, and they should be protected. No Kiwi wants to work under those conditions, and that's another reason why we should care. Why are the foreign fishing boats in New Zealand fishing? The answer was because there was not enough New Zealand fishing vessels to fish the fish that the government said that you could fish under quota. So therefore, New Zealand companies were going into partnership with foreign companies to bring the fishing vessels in. But guess what? There's not enough New Zealand fishermen to fish this quota on these foreign vessels. And nobody wants to live and work like that. Would you? No, you wouldn't. And if you can speak English and you're a local around here, you're going to know that's unacceptable. But if you're from a third world country like Indonesia, we also had Filipinos on there as well, you don't know. You can't speak English and you can't get any help because nobody cares. They just don't want your job is gone. So nobody cares. They're on there. They're at sea, prisoners on the ship by their masters, the Sajo Oyang Corporation. They can't get off and just swim away. They'll just drown and die. So they can't do that. They've got to just keep doing their job. Then they're afraid if they don't do it to the complete satisfaction of the Sajo Oyang Corporation, that their houses and paddy fields are going to be taken from them and their family will be made homeless and more destitute, causing extreme hardship and extreme poverty. So New Zealand needs to care because we've set up this scenario for it. And it's a fundamental worldwide problem that's happened with these nice fishermen from Indonesia, because they're a skilled workforce. They go around the world and they're being exploited. And this is a first world country and we have laws. So we're simply asking for the court to enforce these laws and let us make a claim over this sister ship, the Oyang 75, which is worth, according to a valuation I've seen, it's a bit old now, but the valuation was for a US $7.5 million to $8 million. So if this $8 million vessel could be sold, it's sufficient to pay the wages outstanding for the 30 fishermen that I'm representing. The other vessel, Oyang 77, that was forfeited, has a valuation, which I've seen back from 2009, with 1.5 million New Zealand dollars. That will be insufficient to pay the wages, because on top of paying the wages, the costs of selling the vessel have to be taken out of the proceeds. Also, the cost of the investigation for the fishing crimes, which will be really substantial because it took quite a long time to do that. The cost of the prosecution, and the fact that court case went on for years just really humps those costs up. And on top of that, the captains were fined hundreds of thousands of dollars for their role in the crimes. They never participated in these hearings where they got the convictions, and they never paid their fines. And so the Crown wants to pay those out of the vessels as well. So fundamentally, we wish to make these applications under Section 256 over the other forfeited property on the basis that the section provides that if you are fishing crew, and these men were, there's absolute proof of that, and you worked on a foreign fishing vessel, and the Oyang 77 and Oyang 75 was a foreign fishing vessel, and if you have an interest in unpaid wages, and we do, they have not been paid, and that was over forfeited property, which is property used in the commission of the crime. And we also say we have an interest in the other forfeited property, bring Oyang 75, other ship to them, but involved in the criminal offending that was owned by their employer. They have an interest in those unpaid wages, and that should be able to be paid for out of the forfeited ship. And those wages were outstanding at the time the vessel was forfeited, so they had an interest in that ship, in the unpaid wages at the time it was forfeited. Therefore, we are submitting that they can make an application under Section 256, round brackets 1, round brackets little c, of the Fisheries Act to claim unpaid wages over the sister ship. And we say that the legislation is simple and straightforward enough that we do not need to jump through additional legal hoops of multiple jurisdictional litigation, of having to arrest the sistership first prior to it being forfeited to claim these wages. In our submission, the legislation 256 sets up a process where any fisherman who has worked on the foreign vessel that has been forfeited is allowed to put a claim into the court to say, I worked on vessels owned by this employer, vessels that have been forfeited for fishing crimes. This is what I got paid. I got paid, for example, $200 a month under my contract. Please look at what I got paid and see if I've been paid the minimum wage, and if I have not, please fix my wages up so that I can get paid what I'm legally entitled to have and have that paid out of the forfeited ship. And we say that is essential because we're dealing with a company here that's unwilling to meet its financial obligations to its crew because it is not in compliance with New Zealand law. Despite whatever it might say, it did not do it, and we can prove it in the Christchurch District Court. We have bank statements. I know what these people have been paid, and they were paid nothing much. A total pittance less than the dresses that I own in my wardrobe. So they need relief from the effects of forfeiture, and it will cause a manifest hardship and injustice if they do not get relief from forfeiture. And the legislation is ultimately aimed to ensure that there is not a manifest injustice. The legislation was set up in 2002 with an amendment to Section 256 that allowed for relief over foreign fishing vessels and for foreign fishermen to be able to claim relief. It shouldn't be an expensive process. It should be a simple process. You should be able to roll up to the forfeiture court and say, hang on a minute, I worked on that ship, or I worked on the sister ship to that ship that got forfeited. Here's what I got paid. Please sort my wages out, Judge. I haven't been paid. And the forfeiture court should be able to take care of it. You cannot expect impoverished third world people that cannot speak English, who are here on work permits, who get shipped off the day they finish their tour of duty here on the fishing vessels, to somehow magically find a lawyer to go around arresting ships before they get forfeited, because they can get forfeited really quickly. And in relation to my clients, it took them 5 years to get a lawyer, because frankly there's not that many Karen Hardings out there willing to do it, you know. And I'm a criminal defence barrister that specialises in drink driving cases, so now I'm doing admiralty law. And why are criminal lawyers now involved in this? Because we have heart, we care, we fight for the underdog, and they don't have any money. And it really does need experienced QC admiralty lawyers, but they're not there, you know, willing to help the impoverished, are they? No. They've got Karen Harding, who specialises in drink driving cases. Do you know what? Traffic law is very simple, and it applies over everything, and basically Section 256 is pretty simple as well. And Justice Davidson supported my submissions and the appeal in the High Court at Christchurch, and this decision of the 18th of December 2015 upheld that the fishermen should be able to make a claim over the sister ship. And we're really only appealing to the Court of Appeal, well, the Sajo Oyang Corporation, because they just don't want to pay wages, and they want the Crown to give them the ships back so they could just carry on. You know, no inconvenience to them. And the Crown, in this regard, the Ministry of Primary Industries, in my submission, has been greedy in keeping the ship and trying to fight us for it. Because they're not saying, okay, you can't claim over the sister ship, but it's okay, we'll sell the ship and we'll make sure all the fishermen are paid. No. They're either going to keep the money for themselves, or they're going to give that ship back to criminal owners. And you know what that means? That's a total windfall to them and causes poverty, hardship to everybody else who worked on that vessel, and it breaches our minimum wage laws. What's the point of having a minimum wage act if we don't enforce it? Where was the enforcement of these rules and regulations? They were missing. So New Zealand's been going around changing the law, but no one's enforcing it. Well, time is up. These men need to be paid, and they need to be paid out of this vessel.